Hello everyone and welcome to a new episode of The People's Lawyer. I hope you've all been doing well during lockdown and are taking good care of yourselves. Unfortunately, there are some amongst us who haven't been so lucky and we're going to be talking about them today. If you are interested in legal issues that are happening in the country and enjoy our content, do subscribe to our channel on YouTube.
Vikas Dubey, a hardened criminal, stormed into a police station, killed an MLA, just to have all the policemen who were witnesses to the incident turn hostile. He had more than 60 cases against him and yet was given bail again and again only to commit more crime, simply because he was serving the people in power.
Varavara Rao, an 81-year-old poet who opposed the practices of the state. On December 31st, he made a speech at Elgaar Parishad in Maharashtra. He was arrested for allegedly instigating the violence that erupted at Bhima Koregaon. The violence that we're talking about here was a few protesters pelting stones, as a result of which one person died. Varavara Rao was booked under the Unlawful Activities Prevention Act on the grounds that he made an inflammatory speech which led to the violence in Bhima Koregaon. We've already covered the UAPA in another video, which you should check out if you want to learn more about it. But coming back to Varavara Rao.
20 साल से हमारे को आदत है अरेस्ट है तो कुछ पहले बाद में 25 केसेस है, ऑल केसेस एक्विटेड है, कुछ केस भी कोई नहीं है. वो 11 साल जेल में रहती थी, बाद में को आदत है हमको.
He has not been convicted of any crime till date. He is extremely vulnerable to COVID-19 and there is little chance of him absconding. Despite these relevant facts, the special court set up by the National Investigation Agency rejected his bail application during the COVID-19 pandemic. As a result, today 81-year-old Varavara Rao has contracted COVID-19. He is experiencing hallucinations and dementia, and his lawyer pleads before the Bombay High Court to let his family meet him, as he is now on his deathbed.
We are all angry as a country when a criminal goes scot-free. Why are we silent when innocent people like activists, lawyers, crusaders are slapped with criminal charges, jailed and harassed by a political and legal system? For what? For exercising their fundamental right of freedom of speech and expression? For committing a crime called dissent? Why is this selective outrage? That is my question to you. This is the new face of terrorism in India today. Are we, the people, comfortable with the fact that people like Varavara Rao, Sudha Bharadwaj, Arun Ferreira have been designated terrorists in the eyes of law like Ajmal Kasab? Can we allow just anyone to be labelled as a terrorist? Are we simply going to accept the narrative that the biggest threat posed to India is by its intellectuals and activists? And this threat is as serious as 26/11? When Pakistani terrorists stormed into the city of Mumbai and mercilessly shot people with their AK-47s? The National Investigation Agency, popularly known as NIA, was specially set up after 26/11 to ensure that such incidents of terrorism never happen in India again. But to use this agency on innocent people like activists, lawyers and crusaders is absolutely uncalled for. Why is the NIA being used to investigate activists and issues of law and order, which happens to be a state subject?
In a series of videos, we are going to discuss the issues of federalism, NIA, the CBI and the center-state relation in terms of law and order. But in this one, let's specifically talk about the denial of bail to Varavara Rao and the other jailed activists during the COVID-19 pandemic. In an effort to decongest prisons, on 23rd March, the Supreme Court passed an order stating that anybody with a conviction of less than 7 years can be left on bail. For this reason, the Supreme Court set up high-powered committees in every state and union territory to look into which categories of prisoners can be released. It was the discretion of this high-powered committee to take into account relevant facts and decide which prisoners would be released on bail. But Maharashtra's high-powered committee decided not to grant bail to any person accused under a special act. Now, a special act includes the Unlawful Activities Prevention Act as well, because it is an anti-terror law. This effectively left out political prisoners like Varavara Rao and Sudha Bharadwaj, who are accused under the UAPA.
Criticizing this move, Justice B.N. Shri Krishna, a former Supreme Court judge, has said, if this is what the high-powered committee has stated, then it's absurd. How can the committee distinguish between prisoners booked for special acts and others? It is like distinguishing between the rich and the poor prisoners.
तो आपका मानना है कि चार्जेस पूरे ट्रम्प्ड अप हैं, फेक हैं और इसमें कोई बेसिस नहीं है?
चार्जेस पूरा फेक है, अबद्दल, पूरा फेक है.
The accusations made against the activists under the UAPA have come under question by none other than Honorable Supreme Court Judge Justice Chandrachud. In the case of Romila Thapar versus Union of India, a group of prominent intellectuals of this country came together and challenged the unlawful manner in which the investigation against these activists was being carried out. They requested the court that a special investigation team, that is an SIT, be set up because there were several political pressures that were coming into play, and therefore a free and impartial investigation was not being carried out. But the plea for an SIT was rejected by the Honorable Supreme Court in its majority opinion on the ground that they did not think that the investigating officer had exercised his power in a malified manner.
However, Justice Chandrachud gave a dissenting opinion and observed that an SIT was required and stated, upon perusing the material, I find that the allegations that each of the 5 individuals arrested on 20th August 2018 is found to be engaged in activities of the nature set out in paragraph 26 of the counter affidavit is taking liberties with the truth. General allegations against the philosophy of a banned organization, its policies and the modalities followed in the execution of its unlawful activities constitute one thing. Linking this to specific activities of named individuals is a distinct matter. In other words, linking an individual to an organization's deeds without substantial evidence is questionable. Crime by association is not permissible as per liberal jurisprudence which our constitution follows.
As he lies in the hospital today, struggling against COVID-19 and fighting for his life, around 100 intellectuals from across the world, including leading thinkers like Noam Chomsky and Harvard professor Homi K. Bhabha, have demanded the release of Varavara Rao. Since 1973, Varavara has been in prison for over 10 years, and as Justice Chandrachud noted in his dissenting opinion in Romila Thapar's case, that Varavara had been acquitted in all the 20 cases that had been filed against him. This tells us that he has been jailed over and over again only for his views which he has propagated peacefully. A deeper question that exists is, can India today afford to have political prisoners based on just what they say? And there is a haunting question that Varavara himself asks in his prison diary called Captive Imagination. As a society, we must answer today. He says, and I quote, "But what if one is found not guilty? Leaving aside the loss of health, family and material comforts, who will compensate for the freedom and time lost? And if I may add here, who will compensate for his life?"